we have anyone here representing the cabinet?
Yes, Cassie Trueblood, Counsel for the Education Professional Standards Board.
Okay. There are staff amendments. Is there a motion for approval of the staff amendments? Motion, second. Without objection, is so ordered. Are there any questions on these regs from members of the subcommittee? Seeing none, please call the next regulation. Thank you.
Department of Law, Office of Civil and Environmental Law, 40 KAR 1040 Emergency and Ordinary. The Ordinary has a staff suggested amendment.
This regulation and the emergency establish a statewide form that can be used to request public records. The staff suggested amendment for the ordinary regulation amends various sections to comply with drafting requirements of KRS Chapter 13A.
Would you please identify yourself for the record?
Yes, Mark Manley on behalf of the Office of Attorney General.
Thank you. There is a staff amendment. Is there a motion for approval of the staff amendment? There's a motion and a second. Without objection, it is so ordered. Any comments or questions from members of the committee? Seeing none, please call the next regulation. Thank you.
Thank you.
Finance and Administration Cabinet, Department of Revenue, 103 KAR 16320, 352, 18020, and 090, 27050, 150. All of those have staff amendments. 103 KAR 27230, 30091, and 120 with staff suggested amendments. 140 and 190, 250. Both of those have staff suggested amendments.
103 KR 16320 amends to update statutory citations and make changes for clarity. 103 KR 16352 amends to update language to comply with KRS Chapter 13A. 103 KR 1820 amends to update existing language as it relates to employer withholding, specifically under withholding and over withholding by the employer. 103 KR 1890 amends to update the type of information that shall be contained in employer payroll withholding and exemption certificate records to conform with KRS Chapter 13A. The staff suggested amendments for 103 KR 16320, 16352, 1820, and 1890 all make changes for clarity and to comply with KRS Chapter 13A.
103-27050 is being amended to add statutory references, update the promulgation statement, add tangible personal property sales examples, provide clarifying language, delete previous guidance related to the taxability of certain sales that are now taxable as the furnishing of landscaping services, and comply with KRS Chapter 13A requirements. 103-27150 is being amended to add a definition for extended warranty services, update the regulation regarding the tax treatment related to service and installation charges related to the sale of tangible personal property, digital property, and taxable services, add examples of transactions where the repair parts and materials used are less than 10% in relation to charges for labor, delete outdated tax treatments, and update the tax treatment of extended warranty services. 103-27230 is being amended to update the title, add statutory citations, update the necessity, function, and conformity paragraph, update the taxability of motor vehicle body shops, provide examples of property consumed within motor vehicle repair and body shop services, and provide guidance on the application of the resale certificate to tangible personal property purchases within the motor vehicle repair and body shop industries. The staff suggested amendments to these regulations amends various sections to comply with the drafting requirements of KRS Chapter 13A and make technical changes.
103 KAR Chapter 30 regs update the tax treatment for farmers, for machinery for new and expanded industry, for energy and energy-producing fields, for interstate and foreign commerce, and for property used in the publication of newspapers. The staff amendments amend various sections to comply with 13A drafting requirements.
Would you please identify yourself for the record?
Good afternoon. I'm Bethany Atkins Rice, Counsel for the Department of Revenue. I have with me here today Richard Dobson, Executive Director for the Office of Sales and Miscellaneous Taxes, as well as Jessica Johnston, who is Executive Director of the Office of Income Taxation for the Department of Revenue.
Thank you. There are staff amendments. Is there a motion for approval of the staff amendments? We have a motion. We have a second. Without objection, is so ordered. Are there any questions from members of the committee? Co-Chair Hale.
Thank you, Mr. Chair. Yes, I have a question, or maybe just you could comment, if you could, please, on KAR 027-150 that's speaking concerning the extended warranty services.
Yes, Representative Hale. This is Richard Dobson. It's 27-150 repairs and reconditioners.
Yes,
the question there.
Yes.
One of the purposes with renewing and updating these regulations is to provide additional guidance that related to recent legislative changes and the extended warranty provisions that went into effect back in the 2018 session. This was as a result of extending or expanding the base of sales tax. It created a lot of different questions for the repair industry and other industries as well. So this regulation just provides some additional guidance that's related to these changes in Chapter 139 due to the legislative expansion of the sales tax base.
So is this just basically updating this, or is there something there that I'm missing, or is it just an update of that of those exemptions, or not those exemptions, but the taxes?
Yes, it's an update explaining how, with the expansion of sales tax to include extended warranties, how that does affect businesses that are involved in repairing tangible personal property, because some of that property may have an extended warranty. And if there is an extended warranty and repairs are done under an extended warranty that was executed from July 1, 2018 forward, then there's a different way to handle those warranties and how the repairs are performed pre-legislation and post-legislation. So this regulation goes into that a little bit. So it's an update. It's providing guidance on law changes that that became effective back in July of 2018.
Thank you.
You're welcome.
Yeah, I've got one question. If someone could explain, it's 30140, energy and energy producing fields. In our summary, it says, it's under item 2 in our summary, it says provide guidance on the energy direct pay exemption for the utility gross receipts tax. Could someone explain that? What's happening there?
Yes, Senator West. The energy direct pay authorization affects both sales and use taxes and our utility gross receipts license taxes. This regulation is being amended. It previously just addressed the procedures involving authorization and eligibility for the energy direct pay for sales and use tax. But the procedures are practically identical for how to apply for the same authorization as it relates to utility gross receipts license tax. So as this regulation is being amended, we went ahead and included the guidance that relates to the local school tax as well. The Department of Revenue has administered this tax since 2005. We've had procedures in place to ensure that businesses can qualify and get the partial exemption and the authorization. But this regulation just provides that guidance in a more public format in the format of the administrative regulation. So we're just providing needed guidance, clarifying, and everything being adopted here is what we already have in our internal procedures.
Thank you. Any other questions? Seeing none, please call the next regulation. Thank you.
Thank you.
State-owned buildings and grounds, 200 KAR 3020 with a staff suggested amendment.
This regulation amends to allow use of department-provided face coverings to prevent or mitigate the spread of disease, to prohibit livestock from state facilities and grounds that are not designed for that purpose, to establish safety standards for deadly weapons that are openly carried at state facilities and grounds, and to add clarifying language and definitions. The staff suggested amendment amends Section 1 to add a definition of face covering, amend Sections 1 and 2 to clarify that the application to use state facilities is for all state property, not just historic, and that it is maintained by the Department for Facilities and Support Services, to allow state agencies to individualize the form if it is substantially similar and approved by the department, to allow the department to delegate authority to review and approve the use applications for specific facilities and grounds to a tenant agency of the facility or grounds, to specify the Division of Historic Properties will continue to oversee use of historic properties, and to require any delegation to be posted on the department's website. It also amends Section 2 to authorize similar delegation for the rental application. It amends Section 3 to remove the requirement that face coverings worn to prevent disease be department provided, as long as they satisfy the components of the new definition, and amends various sections to comply with 13A drafting and formatting requirements.
Would you please identify yourself for the record?
Brian Thomas, General Counsel, Finance and Administration Cabinet.
And Kerry Bishop, Assistant General Counsel with Finance.
Okay. There's staff amendment. Is there a motion for approval of the staff amendment? We have a motion. Do we have a second? Without objection, is so ordered. Are there any? I have a few, but I'll open it up to the committee first. From members on this set of regulations. Okay. Go into detail on what each part is doing. So when I say each part, I mean face masks, livestock, deadly weapons. If you could just add a little detail for the committee and people who are watching from home.
If Mr. Bishop can take up that question.
Certainly, I'd be happy to. So as to the face mask issue during the pandemic, the original regulation that was passed back in 2019, mask was one of the things that was prohibited by the original regulation. Reason being just health and safety concerns. Same reason that individuals are tend to be banned from wearing head coverings when going into a bank or something of that nature. But of course, COVID changed that. I believe the Secretary issued an order, emergency temporary order a while back to say that face masks would be allowed. This regulation just makes that common sense change and says it's something that's explicitly allowed. We accepted the amendment from LRC to say define what a face mask would be, and so that's the face mask change. As to livestock,
so before you go on, so sure. It doesn't mandate, but just simply allows face coverings to be worn in these state-owned buildings, correct?
Correct, that's correct.
Okay.
Oh, and so may I move on now, Senator West?
Sure. Thank you.
As to livestock, specifically exempted out, of course, is any state facility that is explicitly designed for livestock purposes. So it's anything, a fair facility, agricultural intended use, exempted. But on state facilities and grounds where that's not intended, where we don't have measures in place to pick up, clean up, safeguard members of the public nearby from livestock going through, whatever the nature of the livestock, which is defined elsewhere in statute. It just says that in order to have them there, you're required to get permission from the Department for Facilities and Support Services. So it's still conceivable that there could be an event where livestock would be permitted, but all that does, similar to any other event on a state facility, on state grounds or in a state facility, just ensures that there'll be a request to do that, and proper preparations can take place. And I believe the last question went to the deadly weapons. All what we're doing there essentially is just saying it doesn't ban deadly weapons. It doesn't say they're not permitted at all. It's just putting in some safeguards. And those are found in section 3 of the regulation. The specific restrictions are put in place regarding long guns and in handguns specifically. And it basically just puts in clear black and white standards for people to understand about, what constitutes, safe carrying, permitted carrying of a long gun and a handgun on state grounds. And so, for example, it talks about, you're going to keep the muzzle of the firearm pointed up and not pointed at another individual. You're going to keep the safety on. You're not going to have your finger on the trigger. Similarly, for handguns, you're going to have them in a holster, and it's going to have at least 2 retention mechanisms. And I'll admit that's something I had to educate myself a little bit on in preparing this regulation. We had the assistance of the KSP in preparing it. For anyone who's seen an officer walking around with a holstered firearm, what that is there's in the firearms, when it's for individuals knowledgeable about firearms, there are levels of protection to make sure that, for example, if a police officer is carrying around a firearm, someone can't grab it and take it out of their holster. One of those, a very basic one, is just the friction of the holster itself. That's one level of protection. One that you might also have seen have been like a leather strap that snaps down over the handgun so it can't be quickly drawn. My understanding is it goes, from level 1 up to level 4, level 4 being the level of, it's impossible for even if an officer is knocked out and unconscious for someone else to draw that firearm out and, use it against them. And so, these are been working with KSP, what we believe would be good ideas here to help balance, the rights of people who are firearm owners with, health and safety, not only of the general public, but also the firearm owners themselves. If the committee will indulge me, I would analogize it to when people are driving something like airbags, where it doesn't impede your right to drive a vehicle, to have a vehicle. It just slows down the interaction to keep people safer. Similarly, we're slowing down, the rate at some things would happen if people have safeties on. They're not pointing guns at people. It prevents misunderstandings from escalating too quickly, and will, I think, serve everyone better in the end. I think that was the 3 things you wanted us to address: base mass, livestock, and weapons. But if there's anything else, we'd be happy to respond to those as well.
Couple quick questions. So the 2 on the handguns, the 2 steps. So it's safe to say that a police officer carrying a handgun probably has those 2 steps covered. Is that accurate, would you say?
I don't want to misrepresent myself as an expert on this issue, but my understanding from looking into it was that police officers generally have at least what's called a level 2 level, where they have, the friction of their holster, and then the one I've seen the most is just the leather snap over, but they go up from there.
Okay.
So, but yeah, my understanding is level 2 is, the minimum expected from most police. And
back to the livestock question. So I think there was a gentleman last year that was protesting, and he was riding a horse on the grounds across the street. So is it your opinion that that gentleman would be restricted under this new regulation from bringing his horse to the Capitol and protesting in that way, I guess?
Well, on the text itself, I think what the regulation would require is that he would just have to put in a request to bring the horse, onto state grounds. And then just like any other First Amendment activity or demonstration or event on state grounds, it would be reviewed by the commissioner, by the department. And, they would make a decision. They could, grant that will be an execution issue more for the commissioner. But, in making it, he would be looking at the regulation. He would be considering, if it was for this facilities or grounds or any other, the capability of that area to deal with it versus, the interest served by bringing it on. But of course, there'd always be the normal recourse to, it should be subject and content neutral. It'll be just based upon the baseline restrictions in the regulation.
Okay. Yes. Representative Bridges.
Okay. I just have one question, if you don't mind, Mr. Chair. I understand with the livestock on state grounds, a lot of us live in rural areas and communities. Would this require our constituents, such as those of the Amish or Mennonite beliefs that only use horses, to have to get permission before they can go to any state-owned facility, such as a courthouse, a health department, whatever?
That's an excellent question, and that's not something we've gotten a comment about, but it certainly bears consideration.
If I can address that, so this is Brian Thomas. For example, a courthouse, you would travel on the public roads, and so whatever either livestock or other vehicles are authorized on the public streets, that would still be available to people. In addition to that, finance does not dictate the use of the administrative office of the court's facilities. And so, at least for that particular example, I don't think this regulation would be relevant to that use. But when we talk about facilities and grounds, we are literally talking about state property itself. It's the ingress and egress is not generally considered part of that, if that is the question.
Follow up
question.
Sure.
Mr. Chair. Well, I understand you're talking about the county-owned property, whatever, but would that prohibit? Let me make it more specific. Would the people of Kentucky that use horses and buggies, would they be able to come to the state capitol?
So again, I believe they would. I guess anything that is considered part of the public street, this regulation does not impact. If there was going to be an event with livestock, horses, even horses and buggies, then on state facility grounds, then they would need to submit an application to hold such an event.
One more, Mr.
Sure.
Chair.
Yep.
Then how would that affect the gentleman that rides his horse around the Capitol? Is that not public thoroughfare? Why would that prevent that? I'm sort of. There's not a lot of clarity here that concerns me.
I'll let them answer. I think what they're saying is that the public street would be okay, but I get to your question, where does the public street begin and end?
Yes, sir.
Yeah. So proceed, Cabinet, if you would.
And thank you. From my observation, so I don't know if I was able to observe the gentleman that you are referring to. I am aware that an event like that took place, but so if the livestock is being is on state property, on the lawn, et cetera, which I believe that gentleman was, he would need to submit an application to get approval for those events. And when facilities responded, I believe that they would, request that, that person clean up after the livestock, that, that if there was a belief that there would be property damage, that, that would be avoided. But again, that person would submit an application just like any other.
Reinforcing what Brian was just saying, while I think, we could always provide further clarification, I think there is a distinction between, the primary intended focus of this regulation, which is talking about, events and using state facilities and state grounds. And then, what was the situation that was raised, which talks about horses, livestock more as a form of transportation. When you're talking about events and, the requirement to submit an event, request to the department, that intended use is, you're talking about livestock, or you're talking about a horse going across state grounds, and going across the lawn, and going across where other, people are going to be. Whereas in the hypothetical that was raised, and I understand it's a realistic hypothetical, you're talking about someone who's taking a horse as a form of transportation. And again, I'm not an expert on this subject, but I would imagine they're going to be leaving that, that horse, hooked up to a buggy or nearby it in, a state park, in the state parking lot, or, parking facilities. And so while, I will agree it could be something we could issue further clarification on, at the present moment, I think if someone who, a member of the Amish community, Mennonite community, was bringing their, using their horse as a form of transportation, and their intended use was limited to, they're going to leave it, in a parking type area on state grounds, then subject for clarification, it's unlikely that the regulation will be applied against them in that instance.
Senator Alvarado.
So again, I guess you just, that last statement kind of clarified my question was, is the parking lot considered part of the road, or is it part of Capitol grounds? So I mean, if you, let's, again, just using this example, because I think it's a legitimate one. If someone is Amish, brings their buggy, they're going to have, if they're going to come for some event and leave their buggy and their animal somewhere, it'd have to be in the parking lot, I would imagine, and find a place to secure that animal there. They're not just going to come through for a leisurely ride and go back wherever, home, wherever they're going to go to after they're here at the Capitol grounds. But if they're going to leave that animal somewhere, what you're saying is they'd have to get permission to bring that animal on, to leave it in the parking lot effectively, because that isn't part of the main road, and have to be able to tie that up there. That's, I guess, that is a legitimate question, I think, is would they have to get permission, number one. You're saying it would be unlikely that anything would happen to them. That's fine. That's a very lawyerly response, but I mean, we're passing a regulation that has some definitive language in it. So that's the curiosity of, is it possible that they could be cited or have something done against them, their animal taken away? That's the main question. If somebody wants to bring an animal here with a buggy, do they have to get permission to be able to park it in one of the parking lots that we have on the Capitol grounds?
Thank you, Senator. So again, this regulation finance does not have the ability to, impound someone's livestock or horse, or otherwise take possession of it. So this regulation requires applications for capital events and other uses. The ingress and egress, on and off of state property for the purpose of transportation, does not qualify as an event as contemplated by this regulation.
If I could add to that, and again, understanding the committee's concerns, to the extent there's a concern about ambiguity in this regulation regarding that type of scenario, while there could be a clarification, within the structure of this regulation, I think equally likely and perhaps better suited to a clarification and augmentation of the finance regulation that deals explicitly with vehicle parking and traffic control, which is 200 KR 3010, which is right before the regulation at issue today. To the extent that someone who is bringing their horse, using it for transport to state facilities, I think they'd be likely to look at that regulation as to what they're going to do with it once they're here. And admittedly, the regulation doesn't contemplate that scenario, but the regulation on visitation, this one here, visitation to state facilities and visitation to state grounds, it is primarily talking about events and and foot traffic, and what people are doing on foot and organizing an event. And the scenario of what someone's going to do when they bring a vehicle here, if you're going to define livestock as a vehicle, it might be better dealt with in the other regulation that specifically addresses vehicle parking and traffic control.
Representative Marzian, do you have a question?
I do. Thank you.
Please proceed.
So in 27 years of being here, I've never seen a horse and buggy up here at the Capitol. So I think it'd be pretty rare. But if someone should need to get a permit, are they required to clean up the horse droppings? There has to be some responsibility with people that are going to bring a horse.
Thank you, Representative. So when facilities receives applications for state use, we look at the particular uses that are contemplated by the applicant, and in those situations where livestock was going to be brought onto state grounds, one of the provisions would be that the applicant make provisions to clean up after said livestock.
And within this regulation, under Section 3.1b specifically, it does talk about the responsibility of all visitors when they're on state grounds or in state facilities, that they're going to be responsible for vandalism, damage, breakage, other loss or destruction. And I think that could include the cost of cleanup.
Any other questions from members? I don't mean to beat a dead horse with this line of questioning, but I'm sitting here reading the actual regulation itself, and it says livestock shall be prohibited except at facilities designated for livestock-related purposes. So the way I'm reading it, there is no application. They're pretty much prohibited under this regulation, are they not?
Not to my knowledge. The way this regulation is contemplated is that livestock would be prohibited unless an application was submitted and they received approval. And just to add to that a little bit, the current version of this regulation and the current materials incorporated by reference also bans livestock from the Capitol grounds.
I would just add to that, in support of what Brian was saying there, that when you talk about the prohibition, and please correct me if I'm misquoting the language or citing the non-amended version, under the language on livestock, under Section 3.1q, says livestock shall be prohibited, Clause 1, except at facilities designated for livestock-related purposes, unless express written approval is granted by the division. So that was what I was trying to speak to, and not to be misleading on it. That's what it is intended of. Someone can request permission from the division, facilities, to that gentleman with the horse, for example, can request permission. And to the extent that there was any ambiguity, and I apologize for it, that doesn't limit it necessarily to I'm having an event and part of it is horses. They could just submit a letter, submit a written request, submit an email, and the written approval by the division could be in that form. So, it doesn't require someone to necessarily be terribly great at using forms, and they do have the ability to request that permission. They do have the ability to get it granted. And so, in the hypothetical posed regarding the Amish and bringing horses onto park, understand they're probably not going to send an email. They could send a letter, send a written request. They can make a request. It doesn't have to be in a written form. Hey, me and my family are going to come and visit the Capitol. We want to show our kids the Kentucky government. Do we have permission to bring our horse on, park our buggy, and while we tour the Capitol with our family? And the division would have the authority under the existing regulation without any augmentation to look at that and just say, okay, yes, you're bringing your horse on. Here's where you park it. We'll have a post or whatever up for you to secure it to, and that's fine. The existing regulation has that ability.
Thank you. Any other questions from members? I just got one quick comment. I think this regulation was aimed at the gentleman who rode the horse on Capitol grounds last year, and I don't know of any complaints or issues. Maybe there were some horse dropping issues, maybe, I don't know, but I hope this regulation wasn't pointed at one individual. So that's my comment. Any other questions? Seeing none, please call the next regulation. Thank you.
Thank you.
Under Boards and Commissions, Board of Nursing, 201 KAR 20057 with staff suggested amendment.
201 KR 2057 amends to delete references to a repealed statute. Add that an APRN is required to register for a CASPER account within 30 days of obtaining a DEA controlled substance registration certificate via an online portal, and add a grace period of prescriptive authority for 30 days for non-controlled substances if the CAPA-NS ends unexpectedly, but requires prescribing controlled substances to end if the CAPA-CS collaborative agreement unexpectedly ends until the CAPA-CS is resumed or the APRN enters into a new CAPA-CS. The staff suggested amendment amends various sections to comply with KRS Chapter 13A.
Would you please identify yourself for the record?
Good afternoon, Jeff Prather, General Counsel, Board of Nursing.
There is a staff amendment. Is there a motion for approval of the staff amendment? We have a motion. Have second. Without objection, it's so ordered. Any questions from members of the committee? Senator Alvarado, do you not have any questions on this? Okay, good. Please call the next regulation. Thank you.
Thank you.
Board of Chiropractic Examiners, 201 KAR 21035 and 54 with staff suggested amendments. Additionally, 201 KAR 21070, 090, and 100.
These regulations are being amended to clarify the requirements for the official seal of the Board of Chiropractic Examiners, delete the Vice President of the Board from the provision concerning issuing an emergency order to suspend or limit a license, clarify language concerning the National Board of Chiropractic Examiners examination, make technical changes, and clarify the requirements for documentation of a patient visit and requests for records. The staff suggested amendments amend various sections to comply with the drafting requirements of KRS Chapter 13A and make technical changes.
Would you please identify yourself for the record?
August Poske, Board Counsel for the Kentucky Board of Chiropractic Examiners. Good afternoon.
Good afternoon. There are staff amendments. Is there a motion for approval of staff amendments? We have a motion. We have a second. Without objection is so ordered. Any questions from members of the committee on this set of regulations? Seeing none, please call the next regulation. Thank you.
Thank you.
201 Board of Physical Therapy, 201 KAR 22045 with a staff suggested amendment.
201-22045 amends provisions for continued competency for physical therapists to create additional opportunities for continued competency credits and clarify course approval provisions. The staff suggested amendment amends Section 2 to comply with KRS Chapter 13A.
Would you please identify yourself for the record?
Good afternoon. Keith Pointer, excuse me, General Counsel for the Board of Physical Therapy.
I'm sorry. I'm so used to looking at the screen. You're actually here in person. That's
Yes.
awesome. Thank you.
Thank you.
There is staff amendment. Is there a motion for approval of staff amendment? We have a motion. We have a second. Without objection, so ordered. Are there any questions from members of the committee for the gentleman? Seeing none, please call the next regulation. Thank you.
Thank you.
Board of Licensure for Professional Art Therapists, 201 KAR 34070 with an agency amendment.
This administrative regulation establishes conditions for art therapist license holders concerning inactive status, return to active status, and renewal of an expired license. There is an agency amendment that amends to clarify notifications, due dates, and timelines, amends to require that a 2-year extension be automatically granted if the required paperwork is received, amends to clarify that the reactivation of a license is effective upon the date listed in the written notification, and also to comply with the drafting requirements of KRS Chapter 13A.
Would you please identify yourself for the record?
August Poske, appearing for the board.
There is an agency amendment. Is there any discussion on the agency amendment? Is there a motion for approval of the agency amendment? Without objection, it is so ordered. Are there any questions on this set of regulations? Seeing none, please call the next regulation. Thank you.
Board of Durable Medical Equipment, 201 KAR 47010 and 030, both with staff suggested amendments.
201-47010 amends home medical equipment and supplier license requirements and fees to reorganize fees, including to increase fees, delete outdated fees, and establish new fees. 201-47030 amends complaint and disciplinary provisions for licensees of the board to make technical corrections. The staff suggested amendments amend various sections to comply with KRS Chapter 13A.
Would you please identify yourself for the record?
August Poske, Board Counsel for the Board of Durable Medical Equipment Suppliers.
I can see you're working overtime today. There are staff amendments. Is there a motion for approval of staff amendments? We have a motion and a second. Without objection, is so ordered. Any questions or discussion on this set of regulations? Seeing none, please call the next regulation. Thank you.
Thank you.
Kentucky Lottery Corporation, 202 KAR 3020.
This regulation amends to update the procurement procedures for the Kentucky Lottery Corporation.
Would you please identify yourself for the record?
You're on mute, Mike.
Sorry, I thought I clicked that. Good afternoon. My name is Mike Denny, Assistant General Counsel for the Kentucky Lottery Corporation. Also appearing today are Jennifer Moores, the General Counsel for the corporation, and Ellen Benzing, our staff attorney.
Thank you. There are no amendments on this set of regulations. If you could, I know as a legislator, whenever I hear procurement procedures, my ears perk up a little bit. So could you explain what this set of regulations is doing?
Yes, sir. When the lottery was enacted back in the 80s, the statute provided that the lottery could utilize a model procurement code or we could adopt our own regulations, provided we did so by administrative regulation. The lottery opted to adopt its own procurement procedures, but we adopted them in a manner that was consistent with the model procurement code. And that was approved by the legislature back in 96, and we amended that in 99. This is our second group of amendments, and there are several amendments, but we're applying the best value criteria to our request for quotes, not just to IFBs and RFPs. This is pretty technical stuff. The preference for invitation for bids is deleted to reflect current practice that an RFP is just as good as an invitation for bids. Probably the most critical change we made was to increase our small purchase limit under which we can buy a product or service with 3 quotes from 20,000 to 30,000. That's been modified over the years, and this is a modification that was authorized by statute. As inflation creeps up, then it makes sense to raise some of these limits. Sole source procurements have to be approved or have to be justified by the user departments. There's some information in the amendment about cooperative purchasing and when that would be in the best interest of the KLC. There's a provision that modifies the prohibition against contingent fees, since according to recent Attorney General opinions and statute, that's sometimes allowed. And finally, there's a provision in there about employees working while they're also at the lottery. That provision was deleted because that is also addressed in our ethics regulation. That's a summary of our amendments. And I'd also like to say that as I said, our procurement procedures are consistent with the model procurement code, but that being said, the lottery is unique in that we have a board of directors. We have to talk about how our regulation interacts with the model procurement code. So It's consistent with the model procurement code, but it's tailored for the lottery.
So if you're going to deviate from the model procurement code, what problems were you having that would cause you not to adhere to the model procurement code? And obviously, I know the lower level amounts. That's one thing. The 20,000 to 30,000. I can see that. Contingency fees for attorneys. That's a little bit different. But as far as the getting 3 bids and running it through the process, what seemed to be the problem there?
There is no problem there. As I said, we opted to adopt procedures that are consistent with the model procurement code, but it was necessary to tailor our procedures because we're not a state agency and we have some features that are different from state agencies that had to be addressed in our procurement procedures, such as we have a board of directors. That's not addressed in the model procurement code. We also have some standing not feasible to solicit determinations that were necessary. The model procurement code allows for not feasible to solicit determinations, but we have a couple of special ones for media buys and advertising production as an example. For instance, if you want to advertise in a paper or if you want to advertise on a certain billboard, it really doesn't make sense to go through a bid process. Our marketing department wants the ad where they want it in the newspaper where they want it, items like that makes the lottery unique, where we couldn't just use the model procurement code because we have features that make us unique. So we had to, I like to say, tailor our procedures to tailor the model procurement code to our procedures.
And I apologize, I may have misunderstood what you were saying. I thought you said that, you get the 3 bids, but you don't necessarily have to abide by the current code as it pertains to the 3 bids. You can make your own choice or decision at that time.
Well, I'm sorry if you misunderstood,
Yeah,
but that's not the case. We do get the 3 bids. This just raises that small purchase limit to $30,000 for the 3 bids, and that's authorized by statute now.
Any other questions from members? Seeing none, please call the next regulation. Thank you.
Thank you.
Justice and Public Safety Cabinet, Office of the Medical Examiner, 500 KAR 12010, and under Department of Corrections, we have 501 KAR 2050 and 070. None of these have additional amendments.
500-12010 amends to increase the fees for duplicate records to better reflect the actual cost of producing the records. 501-2050 amends to update the form used for transfer request and makes other technical changes. 501-2070 adds a section to implement KRS 532.100 subsection 9, which allows Class D felons to participate in a community work program or other form of work release with the approval of the department.
Would you please identify yourself for the record?
My name is Amy Barker. I'm Assistant General Counsel with the Justice and Public Safety Cabinet. And I also have Kirsty Willard with me. She's the Director for the Division of Local Facilities with the Department of Corrections.
Thank you. There are no amendments. Are there any questions from members on this set of regs? Senator Alvarado.
Thank you very much. Just curious if you could comment as to the need for this. We've had other legislation when it comes to other medical providers in terms of the costs and that are associated with having to reproduce records. I'm just hoping you might be able to comment a bit further on the need for this, why that we're having to increase the fees, and if there's been a large request from different individuals, and who are the people that are typically asking for these records to be reproduced.
Many times it's litigation. It's also people who are like possibly media. It's people who are wanting additional copies. They go directly to the county attorney. There are free copies given to the government entities that are responsible for the coroners. It hasn't been updated in years, so the cost of the reproductions have gone up quite a bit since this regulation was redone.
Thank you, Mr. Chairman. If I can make a quick comment, I mean,
Yes.
that might be, there's been a bill that I've proposed in the past similar to this, just in the medical industry. So it's good to hear that the state government saying, hey, there's an increased cost, we have to cover it. I think a lot of our medical providers out there who are getting numerous kinds of requests through an individual, but again, through litigation and lots of things, people fishing often for ways of filing litigation, have used this. So it might be something for the committee to consider in the future, and maybe for us to consider as a legislature, is to updating the statutes when it comes to all of our providers in terms of providing those costs. Thank you so much.
Thank you. Any other comments from members? Seeing none, please call the next regulation.
Education and Workforce Development Cabinet, Department of Workforce Investment, 787 KAR 1010 20 60 80 90 110 140 150 210 220 260 290 300 and 310. All except 80, 140, and 290 have staff suggested amendments.
787 KR 110 20 60 80 90 and 110, all amend to make technical changes and other changes for clarity, update language to match what is currently utilized by the office, update statutory citations, and update language to reflect the office is now the Office of Unemployment Insurance within the Labor Cabinet. Additionally, 787 KR 110 updates material incorporated by reference and clarifies that some reports may be filed electronically. 787 KR 1020 updates how notices shall be provided to the office. 787 KR 160 provides a portal in which employers can provide required notice and protest the claim to protect the interest of the employer. 787 KR 190 removes materials incorporated by reference that are no longer in use, removes the requirement for unemployed workers to complete a Form UI 480 when they need to request a reissuance of a lost or stolen UI check, and adds current materials incorporated by reference, including an e-claim template. 787 KR 110 includes the definition of interested party. 787 KR 140 updates language to include direct deposit information to be on the benefit payment register. 787 KR 180 and 140 are okay without further amendment. The staff suggested amendments for 787 KR 1010, 1020, 1060, 1090, and 1110, all amend to make changes to comply with KRS Chapter 13A. Additionally, the staff amendments for 1010 and 1020 amend Section 1 to correct the link to the unemployment self-service web portal.
7871150 through 310 amend unemployment insurance provisions including arrangements with other states, employer contribution rates, reports and deadlines, voluntary election to cover employment not otherwise covered, contract construction for purpose of rate assignment, conditions for an employing unit to succeed another, and profiling claimants to identify those likely to exhaust regular benefits. The staff suggested amendments for 150, 210, 220, 260, 300, and 310 amend various sections to comply with KRS Chapter 13A.
Would you please identify yourself for the record?
I'm Anthony Hudgens, Deputy Executive Director of the Office of Unemployment Insurance.
And Erin Bravo, Assistant Deputy General Counsel for the Labor Cabinet.
Thank you. There are staff amendments. Is there a motion for approval of the staff amendments? We have a motion and a second. With that, objection is so ordered. Any questions from members? Seeing none, I've got a quick question on 1090, where we remove the requirement for unemployed workers to complete a Form UI 480. I'm assuming those people would be required to fill out a form online. And if you could comment on that, and basically what I'm getting at is there appears to be a lot of, if not fraud, attempted fraud in this area, and are we doing everything we can to make sure that we protect against fraud against the fund and the state?
And Anthony, did you want me to take this one?
I can speak to it also. Basically, we're just making it easier for claimants to, send an email, send a written request instead of doing a form. The form changes over the years, and people make copies of it, and we're just willing to take a email or a letter written request to make it easier for them.
Gotcha.
And to follow up on that, I think this makes it easier for them to reach out to the Office of Unemployment Insurance to let them know that there may be fraud or that something like this has occurred.
Okay. Any other questions from members? Seeing none, please call the next regulation. Thank you.
Labor Cabinet, Department of Workplace Standards, 803 KAR 2 325 with amendment.
This regulation amends to add definitions, remove duplicative requirements for supply lines in excess of 6 safety belts, lanyards, and lifelines, and roll over protective structures and overhead protection, and to comply with 13A drafting requirements. The staff suggested amendment amends sections 3.3 to remove standards relating to brakes because they are outdated and no longer publicly available, and amends various sections to comply with 13A.
Would you please identify yourself for the record?
Good afternoon, Robin Maples, Department of Workplace Standards, Kentucky Labor Cabinet.
Good afternoon, Chuck Stribling, Kentucky Labor Cabinet, Department of Workplace Standards.
Okay. I've got some other people on my list, but I think we're fine with these members. And I think they may have been presenting on the next reg on the list, which has been deferred. Okay. There are staff amendments. Is there a motion for approval of the staff amendment? There's a motion and a second. Without objection, so ordered. Any comments or questions by members on KR 2325? Seeing none, please call the next regulation. And as noted, KR 25190 has been deferred for today.
So we will move on to Public Protection Cabinet, Department of Insurance, 806 KAR 17240, 270, 280, and 470, all with staff suggested amendments.
806 KAR 17240 amends to update definitions, add references to Annual Report 8 and 9, require insurers to report total claims paid by insurers for various medical and surgical services and mental health and substance use disorder services, make technical and other changes to comply with KRS Chapter 13A, and update material incorporated by reference. 806 KR 17270 amends to update claim forms and make technical changes. 806 KR 17280 amends to incorporate forms by reference, add a definition for healthcare provider or provider, set forth additional information to be included in a registration application, require the insurer or private review agent to submit all correspondence and communication between the parties concerning a denial that is the subject of a complaint, and make various technical corrections. 806 KR 17470 amends to make technical changes. The staff suggests amendments for these 806 KR 17 regulations all make changes for clarity and to comply with KRS Chapter 13A. Additionally, the staff amendment for 806 KR 17280 amends Section 1 to add a definition of health benefit plan and to use a broader definition of insurer.
Would you please identify yourself for the record?
Good afternoon. My name is Abigail Gall. I'm the regulations coordinator here at the department. I also have Chad Thompson, our general counsel, and Sean Orm, who is an executive advisor to the commissioner.
Thank you so much. We have staff amendments. Is there a motion for approval of the staff amendments? We have a motion. We have a second. Without objection, is so ordered. I have a quick question. Go into explain KAR 17280. We just deferred a regulation dealing with workers' comp utilization review. I just want to make sure that utilization review isn't somehow related. I'm assuming it's not, but if you could comment on that.
So thank you for the question, Chairman. It just falls under the scope of private insurers. So you want to elaborate exactly how the process flows? I mean,
I guess my question is, it stands on its own.
Yes.
And is not.
It has no. Yeah, you're correct. It does not relate to.
Okay.
Yes, labor. It only applies to health benefit plans.
Gotcha. That's all I needed to know.
Similar idea of a process, but totally separate entities.
Gotcha. Any other questions from members of the committee? Seeing none, please call the next regulation. Thank you.
Thank you.
Environment Cabinet Public Service Commission, 807 KAR 5015 with staff suggested amendment.
807-5015 establishes procedures for PSC to regulate rates, terms, and conditions for utility pole attachments and access to other utility facilities. The amended after comments version revises definitions, clarifies overlashing requirements, and extends from 90 to 120 the days for a pole owner to submit an invoice to an attacher. The staff suggested amendment amends various sections to comply with KRS Chapter 13A.
Would you please identify yourself for the record?
Yes, my name is Linda Bridwell. I'm the Executive Director of the Public Service Commission. With me today is Jeb Penny, our Executive Advisor, and Ben Bellamy, the staff attorney.
Thank you. We have a staff amendment. Is there a motion for approval of the staff amendment? We have a motion. We have a second. Without objection, it is so ordered. This regulation has generated some interest. I'll put it that way. So let's start out with the PSC, and if you could just give us the just a quick 1 to 2 minute version of what this regulation is doing.
Thank you, Chairman. My name is Jeb Penny, and I'm the Executive Advisor to the Commission. Just a little bit of background, and that in 1983, the Commission, pursuant to federal law, reverse preempted, meaning we preempted the FCC to regulate the pole attachments for cable and television attachments. And since then, the Commission has addressed pole attachment issues just by order or by opinion letter or complaint by utilities. And that's been 36 years with this hodgepodge approach. And so beginning about 3 years ago, the Commission decided that a comprehensive pole attachment regulation was necessary, and almost 2 years ago released a version of it to the different stakeholders, the pole attachers, the pole owners, and through a series of public meetings where we took comment, and this is outside the promulgation process. We took several comments and crafted regulations we ultimately filed with the LRC. And then while the Commission was doing this, the General Assembly enacted House Bill 320, which established a deadline for the Commission of December 31st to promulgate these regulations. This is just a culmination of years of work, and I think most stakeholders are largely accepting of the regulation. Some stakeholders may have quibbles with certain parts of it. But this is a sea change in how the Commission has approached this. And broadly speaking, this proposed regulation creates a uniform process by imposing on pole owners specific timelines and provide provisions by which people seeking to attach to the poles may seek to make new attachments, while trying to minimize the burdens on both utilities and the attachers, while considering the fair allocation of the costs between attachers and the traditional utility customers. There's a few highlights to the regulation, one of which is it establishes a formal complaint process specific to pole attachments to the Commission. Another one is that it codifies one touch make ready work. What that means is that if a new attacher comes into a pole and it doesn't require complex work, it can go ahead and move other attachers' equipment so that the new attacher can then attach to their pole. This is something that I think Google Fiber tried or had the Louisville Metro Council adopt several years ago as an ordinance, and it's popular among other states to speed out the deployment of broadband. Another thing that it does, it streamlines an opportunity for attachers to request what we call high volume requests. If a attacher comes into an area and wants to attach to, say, more than 1,000 poles or more than 1% of the poles, it addresses how that can be handled. It expands the limits under what some other utilities in their tariffs have limited it to. For those that might live in Lexington, MetroNet has been rolling out fiber, and they have had large volume orders with Windstream and Kentucky Utilities in that area. It also creates procedures for overlashing, and this is something that the commission added into the regulation behest of the Kentucky Cable and Broadband Association, where the commission essentially took language from the FCC's statute addressing or regulation addressing overlashing and made a few modifications that placed it in this statute. And what overlashing is when a new attacher can come and actually lash their equipment over an existing attacher. It doesn't require additional space on the pole. And then finally, one of the highlights to the regulation is that it's sought to establish clear responsibilities for the allocation of costs for pole replacements. And in this situation, the commission adopted the FCC's approach, but that it was unreasonable for a utility to impose the entire cost of a pole replacement on a requesting attacher when the attacher is not the sole cost of the replacement. And what I mean in this situation is that if an attacher comes in and wants to attach to a utility pole, but there's no space in the pole, and that utility has to put in a new pole that might be a larger pole, the new attacher, as the cost causer, would have to pay for that cost of the pole. However, one of the concerns of the attachers in this situation, and the commission has instilled safeguards for this, is to prevent the utility from imposing the cost of replacing a pole if that pole to be replaced had been designated to be replaced within the next 2 years, or if upon inspection that pole should have been replaced and the utility had not been properly inspecting that pole. So we think that that was an efficient middle ground for the cost of pole replacements. I do want to emphasize that this is the product of about 3 years of working with different stakeholders on this and various inputs. And I yield to any of your questions.
Thank you so much for that explanation. Really good explanation. We now have some speakers signed up against, for, and in between. So we're going to start with my list, which is Dan Reinhardt representing AT&T Kentucky.
Good afternoon, Chairman West and Chairman Hale, committee members. Thank you very much for the opportunity to speak this afternoon. AT&T is very, very appreciative of the staff's efforts in having pulled this rule together. It's been a long process. And while not all of AT&T's suggestions were adopted by the commission rule, and we would obviously like to have some more of those adopted, my comments today are going to focus only on one specific area, and that is the area of whether or not the rule is discriminatory against incumbent local telephone companies, ILECs, like AT&T. We believe that the rule itself, as drafted right now, is discriminatory specifically against incumbent local exchange carriers, and we'll go into a little bit about why. It's to be clear, this isn't really about just ensuring fairness from a big picture perspective. It's about avoiding adverse discriminatory results that can disincent AT&T and other incumbent carriers from expanding broadband into unserved and underserved areas. The rule as it stands right now will do exactly that. To achieve the goal of expanding broadband in the Commonwealth, House Bill 320 required the commission to promulgate rules, which it has now done. But importantly, in House Bill 320, the legislature defined the term broadband as any wireline, fixed, wireless, or fixed terrestrial technology having the capacity to transmit data to or from the internet within specific speeds. And It's very clear AT&T has been and is a broadband provider. We are also a local telephone service provider. But the rule as promulgated has three definitions in section 1. Definition 2 defines broadband internet providers. Definition 9 identifies new attachers, and definition 11 identifies telecommunications carriers. And as I've mentioned, AT&T is obviously a telecommunications carrier. AT&T is also obviously a broadband provider. However, those three definitions expressly include language that says that if a company like AT&T has what's known as a joint use agreement with a power company, I'll get into that in a moment, then it no longer qualifies as a broadband internet provider, a telecom carrier, or a new attacher. So by the definition and applicability of the specific insertion of exclusion of companies with joint use agreements from the rule effectively doesn't apply to AT&T in large part. So what are joint use agreements? In essence, joint use agreements are contractual arrangements between pole owners. AT&T is a pole owner. The power companies with whom we have joint use agreements are also pole owners. And the joint use agreements, these contractual relationships, are set up so that there are terms and conditions of our work together. And in often times, those agreements also address attachment rates. Now, at the same time, the power companies that are subject to this rule and AT&T, we have tariff rates out there for cable company attachers, broadband attachers, and what are known as competitive local exchange carriers as attachers to our poles. Those are tariff rates. They're submitted to the commission, and in many cases, particularly with the power companies, they are established in a general rate case where the costs are looked at. So in many cases, the joint use agreements with AT&T are tens of years, decades, and sometimes even longer old. And in large part, the rates that are embedded in those agreements tend to exceed the rates that have been approved by the commission, reviewed by the commission as appropriate as to recover costs, and the rates that we're paying in the joint use agreements are often quite a bit higher. My latest analysis suggests that we pay somewhere between 5 and 7 times the average tariff rate in our joint use agreements. That's across a broad range of them. So, the issues then become, what does that do to AT&T in a competitive environment? House Bill 320 encouraged power companies, and particularly cooperative power companies, to establish broadband affiliates, to go into the broadband business. And under the rule as promulgated, those companies can come to AT&T and demand AT&T's low tariff rates to attach to our poles. On the flip side, the parent companies of those incipient or new entrant broadband providers have pole attachment agreements with us or joint use agreements with us and tariffs at lower rates. But we, under the terms of the rule, wouldn't qualify for the lower tariff rates. We see this as a competitive disadvantage, particularly with the expansion of federal funding for the expansion of broadband into unserved and underserved areas. To the extent AT&T would be in a bidding situation to expand broadband into underserved or unserved areas, AT&T would be expressly disadvantaged by being forced to stay with joint use rates. You might ask, why don't we just renegotiate new rates? It's a good question. especially considering that the rates have been around for some time and we know that they've been high. But what we've run into in this, even in this year, we've tried to enter into negotiations with cooperative power companies, with at least one investor-owned utility, and the response from the investor-owned utility was, "You don't like the rates? File a complaint." If the reaction from the cooperative power companies actually have ranged from talk to us after the rules are dealt with at the legislature and the commission, to another company who, even after probably 4 or 5 attempts of communications with them, including sending certified letters to them, we received absolutely no response to our requesting to negotiate. And in that environment, AT&T will be left with only one option if the rules go in as proposed, and that is to file complaints against these companies for unjust, unreasonable rates, which the commission has already acknowledged in previous cases, or a previous case at least, that the rates that the telephone companies ought to be paying for attachments to power company poles ought to be similar to what cable TV and competitive local exchange carriers should pay. So what's the solution? I think the solution is very simple. In definitions 2, 9, and 11 that are on page 318 and 319 of your review packet this afternoon, we would propose the removal of any language that ties or limits or restricts the definition that would exclude carriers with joint use agreements. Second, in section 3 of the proposed rule, subsection 7, it requires filing of compliance tariffs in the spring of next year. Filing by February 28 with proposed effective dates the end of March. AT&T has provided a letter to the committee on the 8th of October that gives specific language, but just for the record, we would propose adding language to the end of that subsection that said, and I'll read the whole subsection, tariffs conforming to the requirements of this administrative regulation and with proposed effective date of no later than March 31 shall be filed by February 28, 2022. That's the existing language. AT&T would propose adding, absent express agreement by the contracting parties to ratify rates that differ from tariff rates, existing special contracts and joint use agreements shall conform their pricing to that in the tariffs filed pursuant to this subsection no later than March 31. So in short, AT&T wants to save the commission a lot of administrative headache by avoiding AT&T having and other carriers having to come to the commission repeatedly and individually on a company by company basis to obtain just, reasonable, equitable rates that are available to competitors of AT&T. And that'll conclude my comments for the moment. Thank you.
Thank you. In this section, what I'm going to do is now I'm going to have the people signed up to speak in favor of the regulation go ahead and speak. And then after they're done, we'll take questions for everyone, for members. So if Eric Langley.
Good afternoon. Can you hear me?
Yes, sir. You have the floor.
Great. First of all, thank you for the opportunity to speak to the committee. My name is Eric Langley, and I'm here today on behalf of LG&E KU, Kentucky Power, and Duke Energy Kentucky. And Mr. Reinhardt laid out a lot just then that will require some unpacking, but I'm going to attempt to do it as efficiently as possible. And let me start by saying this. The premise of what Mr. Reinhardt just said is that AT&T is no different than the cable television and CLEC attachers on utility poles. That isn't just untrue in a general sense. It has been found to be untrue in the proceeding, in the underlying proceeding before the commission. It's also been found to be untrue in every case tested on this issue within the FCC. Mr. Reinhardt referenced one case from the commission from probably 15 years ago. Actually, it was a series of cases in which the Kentucky Public Service Commission rendered, I believe, 4 separate opinions where they found in one instance that a cooperative telephone company's attachments were similar enough to cable TV attachments that they should be treated the same for rate purposes. But the commission, the Kentucky Public Service Commission, also went out of its way to say that that was by no means a broad finding about the similarities between ILEC attachments and CATV attachments as a general matter, and also specifically said that that holding shouldn't be interpreted beyond the specific parties to that case. I understand where Mr. Reinhardt and AT&T are coming from when they talk about wanting non-discriminatory rates, terms, and conditions. The problem, though, is if these regulations treat entities like AT&T for tariff and access purposes the same as CATVs and CLECs, which are the entities that have historically taken service through the tariff, it would discriminate against those entities because companies like AT&T and Windstream and the other ILECs have gained access to utility poles on decidedly different and more favorable terms and conditions than their so-called competitors. And this is why the Kentucky Public Service Commission has always treated these joint use agreements differently. Not only are joint use agreements different as a general rule from the entities that take service under the tariff, but joint use agreements themselves are variable, which is why a one-size-fits-all regulation would never work for these agreements. And Mr. Reinhardt referenced the rates, which is, by the way, one component of a sophisticated multi-part agreement as being 5 to 7 times higher. I don't know exactly what rates he's referring to, but in many instances, they are significantly lower. So for example, in one of the joint use agreements between AT&T and Kentucky Utilities, there's no rental payment at all. The whole premise of the relationship is that the parties are each going to own a particular share of poles and that they share in the ownership cost of the jointly used network in that way. And so the regulation as amended by the commission specifically recognizes all of the concerns that I have just raised with the position taken by AT&T in this matter, which is why it is necessary to exclude them as they are in the current version of the reg from the definition of broadband provider and from the definition of telecommunications carrier. Now, all of that aside, there's yet another issue, and that is that if the ILECs like AT&T have access to electric utility poles under the reg, it doesn't work both ways. And so electric utilities, what would happen with the agreements that they have? Where would they even have a right of access to telephone poles? Duke Energy Kentucky, Kentucky Power, and LG&E KU collectively attached to tens of thousands of poles owned by AT&T and other ILECs. And doing what AT&T is asking here, and those attachments, by the way, are pursuant to the joint use agreements, and doing what AT&T is asking here would throw those agreements into great disarray. And so I'll conclude by saying that the electric utilities support the regulation as submitted by the commission. That doesn't mean that we agree with every last piece of it. As Mr. Reinhardt referenced, and he and I actually agree on this, there are pieces of the regulation that we would have liked to see come out a bit differently. But the commission was tasked with balancing a very important interest by many different stakeholders, and they did a very good job of doing that. But it is in fact a delicate balance, which is why we support the rule as submitted and not with any further revisions.
Thank you so much. Up next, we have Jason Keller. He is in the room. Please identify yourself for the record and proceed. Microphone.
How's that?
That's better. Thank you.
Great. Thank you. My name is Jason Keller. I'm Vice President of Government Affairs and Regulatory Strategy for Charter Communications, and I also serve as Chairman of the Kentucky Broadband and Cable Association, which represents numerous cable providers that offer high-speed, reliable internet service to more than 1.5 million Kentucky families and businesses. Although my company has invested billions into a network that spans more than 10,000 miles of fiber across the Commonwealth, we recognize that more needs to be done to expand service to areas where broadband is not available. That's why Charter was proud to recently announce an investment of more than $150 million, including over $100 million in private capital and $58 million award from the Federal Communications Commission to extend service to more than 30,000 Kentucky homes and businesses that don't have access to broadband today. And we were also proud to recently announce a major partnership with Scott County, an $18 million total investment to expand service to another 5,300 homes that don't have access to broadband. And we look forward to participating in the State Broadband Deployment Fund. And I want to take this opportunity to thank the General Assembly for allocating $250 million towards that important program. But the funding is just one element of expanding broadband service in rural areas. An equally important component is building the broadband infrastructure in a timely, efficient manner. For many months, we've talked about the critical role that pole attachments play in constructing broadband infrastructure. And that's because approximately 90% of our planned expansion of fiber across Kentucky is expected to be aerial. Or put more succinctly, the fiber that hangs from poles that traverse the Commonwealth's rural areas. And that's why I'm here today, to comment on the pole attachment regulations recently released by the PSC. And I want to first say that we're grateful to the Commission for taking up this important issue. Currently, there is no one set of rules by which broadband providers like my company must follow to attach to utility poles. The various owners of these poles across the state often have different sets of rules and processes for attaching to poles, creating a patchwork of standards and processes. The Commission's work has, to a large degree, addressed this problem. The proposed regulations in front of you establish reasonable permitting standards, fair provisions related to overlashing fiber lines, solid dispute resolution timetables, one-touch make-ready provisions, and the regulations took an important first step towards addressing the critical issue of replacing old, outdated utility poles. We appreciate the work that the Commission has done to tackle these issues, as the focus now turns towards the important process of implementing the regulations. And we look forward to continue working with the Commission and utility pole owners to ensure the regulations are implemented with clarity and uniformity, particularly in how the important pole replacement provisions are applied. And as our rural broadband build-out continues and expands, we look forward to engaging with the General Assembly regarding ways to ensure service is deployed more quickly. And this includes the possibility, as other states have now done, of establishing a new fund specifically to address the costs of replacing aging utility infrastructure in rural areas. The work of deploying broadband in rural areas has never been more important. And that's why I want to again extend our thanks to the PSC for its work on this important issue, and to this committee for allowing me the opportunity to comment. Thank you.
Thank you so much. Might want to stay close. There is no one else on my list. Is anyone else prepared to speak on the issue for or against? Okay. At this time, we'll open it up to questions from members. Any questions from members? Senator Alvarado.
The one thing that caught my eye with the regulation, we used the term overlashing, and it was described well Obviously, when you kind of described it here, but there's no I mean, for a person like myself who, if I didn't hear that definition today, it's not mentioned in the regulation. I know there's several other terms that are defined. And I know we're referencing kind of a federal, I think you mentioned we're referencing federal language. And that might be defined in federal regulations or statutes somewhere. Do we need to add another term in here to describe what overlashing is so that when people read it, it's clear as to what that means?
This is Jeb Penny responding, and thank you for the question, Senator Alvarado. There's something that the commission could take into account, but this is also a fairly niche industry, and I think that anybody that is availing themselves of the tariff would understand what overlashing is. But we could take a look. I'm not sure if the federal government has its own definition of overlashing, but I do not have a ready answer whether or not that the definition is necessary for this regulation.
Yeah, we can come back, Senator Alvarado, if you have additional questions. I do believe Mr. Langley wants to maybe respond or speak on issues as they pertain to cable providers. Is that true?
Senator West, no. If what you're referring to is Mr. Keller's comments, I have no response.
Okay. Any other questions from members? I have one question. My question is for Mr. Reinhardt, representing AT&T. What's the approximate time frame for these joint use agreements?
So, Chairman, are you asking about the age of them?
Yeah. So, for instance, if I'm assuming these joint use agreements are contracts.
Yes, they are.
It's a contract between AT&T and electric co-op or KU or someone of that nature. And so, would those be 10-year agreements or 5-year agreements or 20-year agreements? What's a normal JUA?
There's almost no normal with the joint use agreements. We have agreements that originated in the 1970s and prior. We have one that's with a large investor-owned company that was originally written in 1917. Oftentimes they are set up with either a short specified term, 1, 3, or 5 years. And then they tend to be annually automatically renewable on a notice basis. But an awful lot of them also have clauses in them that if you terminate the agreement or if you're negotiating the agreement and you cannot reach a negotiated settlement on what the rates ought to be or what other terms and conditions should be, that there becomes a stasis imposed under the current writing of them, that the agreement will stay in place for a couple extra years until you have more time to talk about the rates. So largely they're late 90s, early 2000s with 1 to 3 to 5 year terms with annual renewable after the initial term.
So one further question, then we'll open it back up. So I'm having a little problem following. If, let's say, for instance, Mr. Langley referred to a joint use agreement with the KU, and let's say there's zero. You as two entities, you just have an agreement. I can use your polls, you can use my polls. So that number would be 0. Under your proposal, would AT&T start paying KU a tariff rate on that poll? Or is, I guess my main question is it across the board, you accept the new rates, the new tariff rates, and do away with the joint use agreements? Or is it a case-by-case basis?
It would be more of a case-by-case basis, Chairman. The concept that we've proposed in the language would be that absent an express agreement by the contracting parties to ratify different rates, the tariff rates would apply. So joint use agreements, special contracts that are mentioned in the rules are permissible ways of not having to have the tariff rates, terms, and conditions. Mr. Langley, so in essence, we would, if we chose to open under the suggested change, we would contact each one of the companies. We would either reach agreement on the rates or the rates as they are, or as they would change to be equivalent to the tariff. It would be company by company basis.
Thank you. Right now, we'll pause with questions from members and open it back up to speakers. Do any of the speakers want to comment?
Mr. Chairman, this is Jeb Penny with the Public Service Commission. Am I considered a speaker?
You are considered a speaker.
Okay. I did not want to overstep my authority. First, I was remiss in not thanking the committee for hearing this regulation. And I also want to thank the various staff members for their patience in getting this filed through the door of the LRC. I just want to make a brief response to what Mr. Reinhardt had said. And one thing to take into account, and the FCC acknowledges this. Actually, let me take one quick step back. When I said that the commission reverse preempted the FCC on pole attachment regulations, it joined a group of 21 other states plus the District of Columbia of states that set their own rules for pole attachments. And so they have various rules, but the FCC is often looked to for the rules and regulations of pole attachments. And what they have said about incumbent local exchange carriers like AT&T is that while incumbent local exchange carriers are entitled to fair, just, and reasonable rates, they're entitled to fair, just, and reasonable rates for pole attachments, but they are not, they do not take the right of mandatory access that comes with being able to take or being labeled as, say, a new attacher or internet broadband provider underneath the PSC regulation or underneath the federal statutes. The reason being the FCC acknowledges this, and I think that Mr. Langley touched upon this, is that the AT&Ts of the world are not similarly situated to other broadband providers. Other broadband providers do not own their own poles. Other broadband providers do not have the infrastructure in place that the incumbent local exchange carriers provide. And that's why the FCC hasn't gone so far as to mandate access to electric poles for incumbent local exchange carriers. And it's with that eye that the commission also excluded the parties to joint use agreements to the pole attachment regulations. Now, I will point out that I'm not quite sure how long AT&T Kentucky or its predecessors have been operating in Kentucky, but I will say that I know that they have a statewide franchise as of the last Kentucky state constitution. So they've been around for a while, and the pole attachment regulations, or the pole attachment jurisdiction of the commission has been in effect since 1983. And to the best of my knowledge, during that period of time, AT&T has not approached, or any incumbent besides any incumbent local exchange carrier, say for one rural carrier, has approached the commission with a complaint under a joint use agreement that any of the rates, terms, and conditions are fair, unfair, unjust, or unreasonable. The commission still has that authority to take those complaints and to look at the rates and terms and conditions of the joint use agreements so the incumbents are protected. And furthermore, I do know that the incumbents have participated in various rate cases with the electric utilities to reach agreements and even to install certain terms and conditions into the tariffs of the utilities with pole attachments. And so that's a look into the commission's philosophy and why incumbents are excluded from the definition of new attacher or internet broadband provider. And thank you very much. Do you all have any further follow-up questions for me on that issue?
We're going to hold those questions for just a second. Do we have any other speakers who would like to jump back in?
Chairman West, Chairman Hale, Dan Reinhardt with AT&T. I understand Mr. Penny's and Mr. Langley's positions. But one of the things about the attachment complaints, in terms of AT&T's active approaching the commission with potential complaints, they are lengthy, administrative, difficult, time-consuming, costly things to do. And we see getting the access to reasonable pole attachment rates through these regulations as a way of saving the commission significant amounts of time, money, and effort, as well as AT&T and the power companies. While the power companies might disagree with the rate outcome, we believe that it would be beneficial to have access to it. In terms of what the FCC has done relative to telephone company access to power company poles, there is federal legislation that overtly carves out incumbent telephone companies from certain access. For example, the Cable Act of 1979 gave cable TV companies express legal access or right of access to telephone company poles, power company poles, and did not grant that to incumbent local telephone companies. But beginning in 2011, expanded in 2015, and again in 2018, the FCC overtly adopted rules that specified what rates the incumbent local telephone companies should be able to obtain from power companies in non-reverse preemption states. So while we don't have a statutory right of access, the commission, the FCC, has overtly said that we do have a statutory right to just and reasonable rates. And Mr. Penny's reference to the 2007 case, Mr. Langley's reference to that as a single exception, the commission laid out very, very clearly that incumbent local telephone companies would be eligible to have just and reasonable rates. And it's our opinion that those just and reasonable rates are the ones that are established by the individual power companies in their tariffs. With that, we would still argue that the definitions that exclude AT&T from being defined as a broadband provider, a local carrier, et cetera, be modified, and that we would ask for access to the tariff rates through these rules. Thank you.
Thank you. Now we will open up for additional questions. Any members have questions on this set of regulations? This is a very, very important topic, and so I am going to spend a little bit extra time here. Going back, any speakers want to add any additional comment? Seeing none, please call the next regulator. Co-Chair Hale has a question.
Thank you, Mr. Chairman. We've spent a lot of time on this regulation, which that's perfectly fine. Mr. Penny and Mr. Langley and Mr. Keller have gave some very good testimony, and it seems like there has been a lot of time put into this and a lot of research and studied on this. And Mr. Reinhardt, I'm just going to ask you this question, if you don't mind, sir. Hearing all that, what are you really asking this committee to do? What was you really wanting us to do here today?
Chairman Hale, it's very simple. One would be to modify the three definitions that would overtly exclude incumbent local telephone companies from the applicability of this rule as a broadband provider, a local telephone company, et cetera. And then second, to modify Section 3, subparagraph 7, to allow for AT&T to obtain tariff rates that are identified as just, reasonable for the power companies.
Thank you.
Please, done. Okay. Any further questions from members? Seeing none, please call the next regulation. Thank you.
Public Protection Cabinet, Kentucky Horse Racing Commission, 810 KAR 4040 with staff suggested amendment.
This regulation amends to specify precisely when a riding crop can and cannot be used during a race. The staff amendment amends Section 15 to comply with the requirements.
I'm getting there. Please identify yourself for the record.
Hello, my name is Jennifer Wolsing. I'm the General Counsel of the Kentucky Horse Racing Commission. With me, but off camera, is Executive Director Mark Guilfoyle. And behind me is our new Deputy General Counsel, Sean Dutta.
That is wonderful, Mrs. Wolsing. That's a really nice deer there in your office. How did you get that deer?
The deer happens to be a deer, I guess, that came from Mark Guilfoyle.
I'm assuming, yeah, I assumed that was the case. Really nice deer. There is a staff amendment. Is there a motion for approval of the staff amendment? I have a motion and a second. Without objection, it is so ordered. This is Kentucky, so horses are very, very important. So explain to us this whole riding crop issue. I know it's almost the end of the meeting, but this is very important to Kentucky, and we are trying to, as a state and legislature, protect the industry when it comes to people that would shut down horse racing. So if you could just take 30 seconds and just kind of explain the need for this regulation.
I'll be happy to. This regulatory amendment is a compromise measure, and the Kentucky Horse Racing Commission worked very closely with not only the Jockeys Guild, but our legislators to come up with a solution that would allow jockeys to use the crop in Kentucky in a safe and humane fashion. We would like to extend our thanks to not only the Jockeys Guild, but also the legislators for their valuable thanks and input in crafting what we think will be a regulation that will actually become the national crop rule. This particular regulation amendment has some major proposed changes. Specifically, the use of the riding crop will be allowed in certain ways, such as no more than 6 times in the overhand fashion, no more than 2 times in succession. It can always be used to avoid or prevent a dangerous situation or to preserve the safety of racing participants and/or horses. And if necessary, the crop can be used in a backhanded or underhanded fashion from the 3/8 pole to the finish line, and that won't count toward the use of the crop 6 times in the overhand fashion. Also allow a certain amount of tapping of the horse in the shoulder in the down position, as long as both hands are holding the reins and touching the horse's neck, as well as showing or waving the crop without contact to the horse. We will never have an incident where the jockey will use the crop with his wrist above the helmet height. And there are various penalties that we have implemented. Specifically, we will allow for either a minimum fine of $500 or a minimum suspension of 3 days. If the violation is considered to be egregious or intentional by our racing stewards, then the stewards may impose both a fine and a suspension. And there are various factors that the stewards can consider in determining whether a violation was egregious or intentional.
Thank you. As we can see, a lot of thought has gone into this regulation before us today. Any questions from members of the committee? Seeing none. Oh, do you have a question, Co-Chair?
No.
Okay. Seeing none, please call the next regulation. Thank you.
Cabinet for Health and Family Services, Department for Public Health, 902 KAR 48010, 020, 030, and 040. There are no additional amendments.
These regulations amend to update definitions to incorporate by reference various applications, including certification as a lead hazard inspector, risk assessor, supervisor, project designer, abatement worker, or sampling technician, certification as a lead hazard company, and accreditation for lead hazard training. It additionally amends to clarify abatement floor plan requirements, cite to EPA hazard values, and to make KRS 13A drafting changes.
Would you please identify yourself for the record?
Hi, this is Julie Brooks, Regulation Coordinator for the Department for Public Health. And I have Jennifer Burt, the Branch Manager for the Public Safety Branch, and Amber Agee with the Lead Abatement Program in the room with me.
Thank you so much. As was stated, there are no amendments to this regulation. Do we have any questions from members? Senator Alvarado.
Thank you, Mr. Chairman, and thank you all for this. I think a lot of times people just brush over the importance of lead control, obviously for children, a lot of anemias that are out there. A couple of just real quick questions just so that I can make my quick point. Is lead a legal product in our society?
I am going to defer to Amber for that question. So Amber, is lead illegal?
Yes, lead is a legal product that is used in industrial paints. It is just illegal if it is in paints marketed to homes and areas where children will be.
Thank you. Yes, and that's absolutely correct. It's an element. It's a fundamental chemical element in the table of elements, so it is legal, obviously, as other things like arsenic, mercury, lots of other things that we have regulations for in our industry. And so obviously there's other things that some of us here in the legislature have been pushing for on other topics of also that are of importance that also can cause secondary harm, even though they're legal in our society. And so I thank you for the updates on this. I just wanted to make that point. Thank you, Mr. Chairman.
Thank you, Senator. Any other questions from members? Seeing none, please call the next regulation.
Department for Medicaid Services, 907 KAR 23020 emergency. This does not have additional.
This regulation removes cost sharing and copays in accordance with Senate Bill 55. It establishes when the professional dispensing fee can be assessed. It clarifies clotting factor reimbursement and establishes professional dispensing fees for compounded drugs.
Would you please identify yourself for the record?
Good afternoon. This is Veronica Judy Cecil, Senior Deputy Commissioner for Medicaid.
Hi, everyone. This is Fatima Ali, the Interim Pharmacy Director for Medicaid.
Good afternoon, everyone. My name is Jonathan Scott. I'm the Regulatory and Legislative Advisor for DMS.
Okay, there are no amendments to this regulation. If one of you could please just describe the copay situation with the drugs and how that will work. We've had quite a bit of discussion on copays in this committee. So if you could just touch on that briefly, please.
Sure, I'm happy to take that question. So in accordance with a House bill, actually, that passed in the previous legislative session, the copays are no longer assessed against any of our Medicaid services. So we have removed copays from all of our services.
So this was in response to legislation?
A part of this was to be
regarding
to
copays. Regarding
for the copay, yes, we updated it based on that. Yes.
Okay, thank you. Any questions from members? Seeing none, please call the next regulation. Thank you.
Department of Community-Based Services, 921 KAR 1400 with staff suggested amendment.
921-1400 amends provisions for child support and medical support orders to make technical corrections and update material incorporated by reference. The staff suggested amendment amends various sections to comply with KRS Chapter 13A.
Would you please identify yourself for the record?
I'm Steve Vino, Commissioner of the Department of Income Support.
Hi, I'm Maria Lewis. I'm the Assistant Director of the Division of Child Support.
Thank you so much. We have a staff amendment. Is there a motion for approval of the staff amendment? We have a motion. We have a second. Without objection, is so ordered. Any questions from members of the committee on this issue? Seeing none, please call the next regulation. Thank you.
Under KTAP, Kentucky Works Welfare to Work State Supplementation, 921 KAR 2015 with staff suggested amendment. Under SNAP, 921 KAR 3060. Under Energy Assistance Program Weatherization, 921 KAR 4116. Child Welfare, 922 KAR 1300 with an agency amendment. 380 with a staff suggested amendment. Additionally, we have 922 KAR 1390 and 922 KAR 2160 emergency.
922-2015 amends to increase the reimbursement rate for personal care homes in accordance with House Bill 192 and to establish the standard of need annual cost of living adjustment. The staff amendment amends various sections to comply with 13A.
921 KAR 3060 amends to clarify language relating to intentional program violations upon recommendation of the Office of Inspector General, Kentucky Legal Aid, the Kentucky Equal Justice Center, and the USDA Food and Nutrition Service. 921 KAR 415 amends to delete the requirement that air conditioning units provided through the program be window units only, and to increase the program cooling component benefits due to a federal funding award increase in the Low-Income Home Energy Assistance Program block grant funds. The companion emergency was reviewed at the September meeting. 922 KAR 1300 amends to update standards to conform with statutory and federal changes relating to reasonable and prudent parenting standards, transportation safety, and the use of physical management. It also amends to increase the minimum age of direct care staff from 18 to 21 and to make technical corrections. The amended after comments version amended definitions, amended to make the age requirement for employees effective on July 1st, 2022, and make the requirement applicable to new hires only. It also amended to authorize siblings to share sleeping quarters, including siblings over the age of 5, to prohibit the use of cameras to monitor youth bedrooms and bathrooms unless the director of the Division of Protection and Permanency has given written consent due to an immediate safety issue for the youth, to allow both physicians and licensed qualified health professionals to provide services to a child, to require documentation of a scheduled dental examination within 30 days of a child's admission, to require that medication be inaccessible to a child, and to incorporate requirements from another regulation for a residential treatment program, a crisis intervention unit, and a group home. The agency amendment amends to provide an exception to the employee age requirement if there is an agreement between the agency and a college or university to employ students. It also amends to restore language to the pre-amended after comments version, stating that the removal of an employee shall be for the duration of the employee investigation, amends to allow both a physician or a licensed qualified healthcare professional to be consulted by the facility if there's evidence that the child may require medical attention, and to provide for a child's medical needs, and to make clarifications.
922-1380 amends the definition of child to include statutory exceptions. The staff amendment amends various sections to comply with 13A. 922-1390 amends to define treatment professional and to prohibit the use of seclusion for forced compliance, retaliation, or as a substitute for appropriate behavioral support.
Would you please identify yourself for the record?
Good afternoon. My name is Laura Beacon, and I'm the Regulation Coordinator for the Department for Community-Based Services.
Good afternoon. I'm Rachel Ratliff, and I am the Legislative Liaison for the Division of Protection and Permanency.
And Dr. Sarah Vanover is also on for our Child Care Administrative Regulation.
Thank you. There are staff amendments. Is there a motion for approval of the staff amendments? There's a motion and a second. Without objection, it is so ordered. There's also an agency amendment. Is there any discussion of the agency amendment? Seeing none, is there a motion for approval of the agency amendment? There's a motion and a second. Without objection, it is so ordered. My only question to start out, there's no one to sign up. There's no one signed up to speak against these regulations. My question is, how did the public comment period go? And it seems like a lot of changes to the child welfare regs. Was there a lot of public comment, or how did those?
For the child welfare regulations,
Yes.
There was actually only one commenter. The Children's Alliance commented. They do thoroughly review every child welfare related administrative regulation that we file. It is always helpful to have extra sets of eyes. As you know, these were ordinary administrative regulations, not emergency. So we were just glad to have their review and thoughts, and we did make almost every change that they requested in their submitted comments. So the amended after comments version is lengthy as well. We had considered condensing two very related administrative regulations prior to filing. The Children's Alliance in their submitted comments also requested that we condense those administrative regulations. So you will see that in 92 KR 1300 at the back of the reg. It looks like there's a lot of new language. That is actually language that was in 92 KR 1390. And once these changes go into effect in 1300, we will repeal or withdraw 1390 so that all of these standards are in one place, make it easier on us and on the regulated entities. But the Children's Alliance, after we filed our amended after comments, the Children's Alliance did follow up with a few questions. And again, after much discussion, we agreed to make a couple more changes. And that is why we proposed the agency amendment, which we did discuss with the Children's Alliance prior to filing. So they really were with us all through this process. And I believe they did not sign up because they're satisfied with our changes. And I've let them know that if they have any other concerns, I believe they know that they can come talk to us at any time.
Thank you so much. Any other questions from members on this set of regs? Seeing none, thank you so much.
Thank you.
That concludes the October agenda for this committee. We had a lengthy set of regulations today. Thank you for all the members for getting through this. Do we have
the November agenda? Looks like we're scheduled for November 9th at 1 p.m. And we also should take a look at December. There are several caucus retreats.
Yes.
Conflict with our committee meeting.
Yes. The committee will stand at ease. Up here, members, if you have any questions, let us know. But we are thinking December 9th. That's outside of both caucus retreats. Does anybody have any comment? Okay, for now, we'll go with the 9th.
Thank you.
Motion for adjournment.